I'm Jason Klimple. I'm an employment attorney and a partner at Tannenbaum Halpern. And likewise, with respect to my colleague, Andrew Action, who's also with me today, also a partner and an employment attorney at Tannenbaum Halpern. So today we're going to be discussing amendments to New York City's Earned Safe and Sick Time Act, now generally called protected time off, PTO, as it were. And, I think that if you were to draw a Venn diagram of a legal topic uh, where the different rings were chances for liability, the detail level, and the action required, this would be right in the middle. And so, what do I mean by that? Well, first, the amendments that we're going to talk about today, it's not just an FYI, right? It's not just, oh, good to know, that's interesting. The amendments require literally every employer in New York to do something. There is action that is required, not just knowledge, but action. The detail level, the other circle in this Venn diagram, it's not just a small level of detail. The rules, for better or worse, many would say for worse, but for better or worse, the rules are lengthy. There's a lot to know. I think, Andrew, maybe you remember, but the FAQs put out by the city, not all the questions, just the frequently asked questions. It's there's like 100 frequently asked questions. I mean, just
Maybe more.
maybe more than 100, not just questions, frequently asked questions. So the detail is significant here. So there's something to do, something that must be done. There's a lot to know. And then the last circle is, okay, well, okay, we have to do something. There's a lot to know, but what if we don't do it? What does it really mean anything? Does it actually result in any sort of exposure for our organization? And emphatically, yes. Yes, it does. Not only are there private lawsuits that are available to employees in connection with an allegation of depriving them of their sick time, but in our experience, the city is very aggressive. They are very aggressive in policing employer sick leave policies. They are aggressive in requesting copies of your policies and looking at it in detail to ensure it has everything it needs to have in it. So again, and maybe by now people are getting a little tired of this analogy, but if you had three kind of circles intersecting, this would be right at the middle of we have to do something. There's a lot of detail that's involved, and there's significant liability for not doing those things. So from the perspective of perhaps some employers, this is kind of the worst of all worlds from an employment law perspective. Not every presentation we give, including for the Manhattan Chamber of Commerce, is that our attitude. Sometimes we come in saying, hey, this is a best practice. This is good to know. This is a way to mitigate risk. This is a practical action step you can take to make your business more profitable or something to that effect. That's not what we're saying here. That's not this presentation. This presentation is, hey, there is a detail-oriented action step that must be taken, or you're going to be significantly exposed here from a legal perspective. Anything to add as a very fun and exciting overview, Andrew?
No, I think you hit the nail on the head, Jason. There's It's a very important topic. As Jason mentioned, we've been involved in many investigations that have been conducted by the city, the Department of Consumer and Worker Protection, which is the agency that enforces this law. And they can be very aggressive. They're going to ask for your written safe and sick leave policy. They're going to ask to see your pay stubs, your timesheets, everything that they can get their hands on to ensure that employers are complying with this law. They're going to ask for it. We have an obligation to cooperate with those investigations. So it just underscores the importance of what we're talking about here today.
Yeah, and Andrew, you said I hit the nail on the head. That's a little ironic because I think I recently made the analogy, Andrew, that when you're a hammer, everything looks like a nail. And what do I mean by that? What I mean is the city, the people who are investigating this law or allegations of violations of this law, this is like all they do. It's what they do for a living is evaluate compliance with this law. Um, and so for employers who may think, oh, come on, this is silly. Like I'm 90% compliant. I can't worry about all this extra detail. I have a business to run. I have payroll to make. I have insurance to take care of. I have clients to service. I have employees to hire. I have IT issues I need to sort out. This is the last thing I need to deal with. Um, that's fine, and I hear you. But the issue is that the investigators who are investigating allegations of sick leave violations, again, this is their world. This is all they do for the most part. And so they're not going to be sympathetic, in my experience. They're not going to be sympathetic to the discussion that you were too busy to get around to it, or that, well, I couldn't make these amendments because I had this other stuff going on at my place of business. That's not going to fly as a defense. Okay, so what are the changes? First of all, the changes that we're talking about, they are already in effect. That doesn't mean you're too late to come into compliance because we always say if you're out of compliance, the best time to come into compliance is as soon as possible, right? So if you, for whatever reason, miss the cutoff date for making changes, just make the changes as soon as you can, right? The effective date for the amendments was, as Andrew shows on the screen here, February 22nd of this year. And the biggest change is that now, in addition to the paid time off for New York City employees, which, depending on the size of your business, is either 40 hours or 56 hours of paid time. Although there is an exception. Very small employers, what is it, Andrew? Is it four or under four?
Or if you have
And a million?
four or fewer employees in a calendar year, and your
Right.
net income is less than $1 million for the calendar year.
Okay, so subject to the four employee requirement and the net income requirement of $1 million or less than $1 million, then actually it's what 40 hours of unpaid time is the current rule. But for the overwhelming majority of New York City employers, depending on the size of your business, it's 100, right, Andrew? That's the cutoff. You're
Correct.
in the calendar year, how many employees you have in the calendar year, you're either going to have to you have had to provide, this is not new, this is not new. You have had to provide employees with either 40 hours or 56 hours of paid safe and sick time each calendar year. Um, the amendments add unpaid time, unpaid time. So now there's 32 hours of unpaid time in addition to the 40 hours or 56 hours of paid time. Importantly, there's no new reason that employees are able to use the unpaid time compared to the paid time, so they're identical. In other words, the reason that someone might be able to use the paid time, paid safe or sick time, is now the identical reason or reasons that an employee could use the 32 hours of unpaid sick and safe time. Um, Also, one of the other amendments that just took place is a while back, I think it was effective last year. New York State, the state, enacted a new law that, in addition to everything else, in addition to all the other stuff we've been talking about, there is now for employees who are pregnant. There is now a law in New York State that provided 20 hours of paid prenatal leave in each 52-week period. And what New York City amendments did is simply codified that state law essentially to now be part of the New York City law. Okay, so these are the changes that we're going to be talking about today to New York City law. Now, a couple of things to point out, perhaps randomly, but I think they're key points. First of all, administratively, this is challenging. There's a lot to track. This is an operational and administrative challenge. The 32 hours, as we will see, for example, the 32 hours of unpaid sick and safe time does not accrue. It does not accrue. It is given and provided for immediate use in a lump sum for existing employees who were employed as of February 22nd. They were able to use the 32 hours of unpaid time immediately, all of it immediately for a qualifying reason on February 22nd. That is different. That is fundamentally different from the way that the paid leave, that is the existing 40 or 56 hours, works, where they are accruing over time 1 hour of that leave for what? Every 30 hours work. And
Right.
so one is a lump sum, which is 32 hours of unpaid time immediately upon February 22nd of this year. Oh, and by the way, they get, and maybe I'm getting ahead of myself a little bit, but it just makes sense to share it now. The 32 hours they get at the beginning of every subsequent calendar year. Every subsequent calendar year, they get it immediately. Whereas, as I just said, the 40 hours or the 56 hours, usually paid, unpaid for very small employers, usually paid, that accrues over time. And so fundamentally, the ability to use the two different buckets, paid and unpaid, they're different in that one is given as a lump sum immediately, whereas the other accrues over the course of a calendar year. Now, talking about calendar year, only the government could come up with the interesting definition that the definition of calendar year means something other than calendar year. Calendar year means a 12-month period, a contiguous 12-month period as defined by the employer. Now, most employers are going to elect that their calendar year for sick leave and safe leave purposes is going to coincide with the actual calendar year. That is January 1st through December 31st. But that is not necessarily a requirement. If an employer wanted to, an employer could pick a different 12-month contiguous period. So, for instance, it could align with the financial year, the employer's financial year. Note that that is different. So earned, safe, and sick time, the 32 hours on the one hand and the 40 or 56 hours on the other hand, that's measured by a calendar year to be determined by the employer. That's fundamentally different than the prenatal leave, right? The prenatal leave is not measured on a calendar year period. The prenatal leave is measured on a rolling 52-week period. So the employee is permitted to take 20 hours of paid prenatal leave in a rolling 52-week period. That doesn't necessarily coincide or align with any specific calendar year. So this is a call for employers to recognize that, yeah, there's a bunch of stuff that has to be tracked here. There's no doubt, and I'm not, but by saying this, I'm just acknowledging it. This is a law that requires employers to really roll up their sleeves and work with their HR, operational, and even their tech people to figure out how this stuff is going to be carefully tracked and recorded. I have nothing else on this slide, Andrew.
Moving on.
All right, so some of this stuff I've already covered, if not all of it. The 32 hours, as I said, well, for you employers who have employees now, that sick time is available now. It was available as of February 22nd of this year, and then next year, whatever their remaining bank is at the end of the net out of at the end of the calendar year. Again, calendar year that you as an employer define. Most employers are going to define it as January 1st to December 31st. But whatever you define as your calendar year, which by the way has to be defined in your notice and policy that you give to employees, you have to actually fill in. I think there's a place that says our calendar year is, and then you as an employer have to fill it in. Anyway, at the end of the calendar year, whatever unpaid time they have does not roll over from one calendar year to the next. They lose whatever unpaid time they had not used in that calendar year. Instead, the employees are given a fresh, full bucket of 32 hours. So the very next year, as of the first day of the next calendar year, they get 32 hours of new unpaid sick time that is immediately available. That's different, by the way. That's different, by the way, than the regular, what is typically the earned sick or safe paid time, which does roll over. Does roll over. That is accrued but unused, earned safe and sick time does roll over from one calendar year to the next. Usually, as we've said, the paid variety, if you will, that does roll over from one calendar year to the next, subject, however, to usage, right? You still can put in your policy, and Andrew, correct me if I'm wrong, but you can still put in your policy a cap on usage so that they still can't use more than the allotted amount. So,
That's right. You have to allow your employees in terms of the paid time off, the paid safe and sick leave. You have to allow them to carry over their unused time from year to year, whatever you elect that to be. But you can still implement a usage cap, meaning the employee can only use 40 or 56 hours of paid time in the calendar year. The purpose of the rollover is so that if there's any unused time, they have it immediately available for use at the beginning of the new calendar year, if there's time to be rolled over. But again, you can still limit their usage to 40 or 56 hours as long as you have that in your policy.
right, I was going to say
If
big requirement here, Andrew, is that it must be in your policy. I can't emphasize how important that is. If, as an employer, you try to enforce some rule like that against the employee and it's not in your policy, the city takes the position that, well, you can't enforce that rule because it wasn't in your policy. So a lot of this stuff that as an employer, it's our right. So it's our right to cap paid sick time usage. It's our right, Andrew, to request certain limited documentation of the need to use paid sick or safe time if an employee is going to be absent for more than 3 consecutive business days, but only if it's in our policy. Only if it's in our policy. And the city is very firm on this, which is, look, you have some rights, employer, under the law, including to prevent abuse. Employees who maybe are abusing sick time. But they're taking time off, and guess who we see on the jumbo screen of the Mets game? The same employee who had to use sick time that day. All of a sudden, they're at Probably more likely a Yankees fan, actually, Andrew, now that I think about it. More likely to cheat, of course. Uh, but you have to have it in your policy. So if you want to take disciplinary action against an employee for misusing or abusing sick or safe time, the city takes the position that, sure, you can do that, but it has to be in your written safe and sick time policies. Incredibly important. Um, you cannot retaliate against employees for even asking for unpaid or paid sick and safe time. Now, that's not to suggest that you could not um, terminate an employee for some completely independent reason that is legitimate. It's a legitimate business reason unrelated to the request to take unpaid safe or sick time, or paid or unpaid sick or safe time. But just be careful though. Think about the optics of that. If an employee requests paid time off and the very next day they're fired for some ostensibly independent reason, or they're disciplined for some ostensibly independent reason, you have to think about the optics of that, and you may want to get HR or counsel involved to ensure that that's being properly documented, that you're buttoned up with respect to that issue. Anything else on this slide, Andrew?
Yeah, Jason, just one question. Now employees, as you mentioned, they have the paid sick leave that they've accrued, the 40 or 56 hours. They also now have 32 hours of unpaid sick leave available to them. If they request time off for one of the permitted reasons under the law, which do they use first? Which does an employer apply first?
Yeah, it's an interesting question. I don't know, Andrew. What do you think? I think there's mixed opinions about this. The law pretty clearly says that there's a hierarchy of usages, and paid leave has to come first. So
Yeah,
if there was an order of operations here, the employee is entitled to take and can take their available paid leave first, right? So if you're
yeah,
doing an order of operations, because you're tracking these different buckets. However, and this is a question we've got, you cannot require the employee to take paid leave. And in fact, the opposite is true. If the employee wants to use unpaid time for whatever reason, maybe the employee is anticipating that later in the year they're going to be out for surgery or something. And you know what? Because of cash flow or the way that it works or some other benefits they have, they want to use their paid leave later in the year for that surgery or that operation or something like that. It is the employee's right. It is their right to use unpaid leave first if they want to. Now, of course, unpaid leave may be used in certain other circumstances too, including if the employee, for example, does not have enough paid leave accrued, or they haven't accrued any paid leave. In those circumstances, the employee is, of course, allowed to use unpaid time. But the general order of operations, Andrew, at least it's my understanding, is that paid leave will come first. But if the employee wants to, the employee is allowed to use their up to 32 hours of unpaid time at their request. Any
yeah.
supplemental
That's
thoughts
right.
there, Andrew?
Yeah, that's right. Tricky question. I think you hit the nail on the head once again, Jason.
More
Uh,
nails? I think we should take this to Home Depot.
the default rule appears to be that if an employee requests time off for a sick leave purpose, that they be permitted or that they use their paid sick leave first before they tap into their unpaid leave. That is, unless they have no paid leave available anymore, or as Jason mentioned, if the employee specifically requests to utilize their unpaid time before using their paid time, they can do that.
Right. It looks like we have a question, Andrew, in the chat. It says, can a company choose not to allow unused, unpaid safe and sick time to roll over from one year to the next? Well, I just want to point out that actually the new 32 hours of unpaid time, actually, it does not. It does not roll over. The new 32 hours of unpaid time that we're talking about today, that's a result of the amendments, does not roll over from one calendar year to the next. Instead, a new 32 hours is simply given as a lump sum immediately upon the beginning of the next calendar year. And once again, that's fundamentally different from the 40 or 6 or 56 hours that was previously the law, and that still remains the law. Um, those hours do roll over, the accrued but unused 40 or 56, depending upon the size of the employer. Those hours do roll over from one calendar year to the next, subject to the employer's cap on usage. Again, a lot of stuff to track, a lot of operational challenges, I would say. It's super important to be well organized and have good administration with respect to this.
Yeah, just one other point, Jason, before we move on, because I've had clients ask me about this as well. If a company has a more generous PTO or even unpaid time off policy, I guess in theory, where at least 32 hours is front loaded or granted to employees at the beginning of each year, and employees can utilize PTO for the same reasons as specified in the New York City sick leave law, then you don't have to provide this additional 32 hours of unpaid time off. So let me just be clear. If an employer already has a more generous and favorable PTO policy where time is granted front loaded to employees at the beginning of each new year, it's sufficient to cover the amount of time required by the sick leave law. They can use PTO for the same permitted purposes under the sick leave law. Provided all those criteria are met, then you don't have to provide an additional 32 hours of unpaid time on top of that.
But
Um,
Andrew, that would have to, just to be clear, the front-loaded PTO that you're describing, Andrew, that would have to cover the 32 hours of unpaid time plus the 40 hours or the 56 hours of possibly paid time, right? I mean, have to cover both of those
correct.
things. It couldn't cover one, just one or the other.
Correct. That's right. I mean, I guess in theory, I don't know how many employers would implement something like this, but I guess in theory, 32 hours could be front loaded and the remainder could be accrued consistent with the sick leave law. Um,
Well, I mean, the 32 hours is front loaded, right? It's front loaded
right,
automatic.
right. The point being, if an employer has a PTO policy that's more generous, right? If that PTO policy at least allows 32 hours to be granted and front loaded at the beginning of each year, and maybe the remainder is accrued over the course of the calendar year, that could comply as well. But your point's well taken, Jason. It has to be, it has to cover at least the 32 hours of unpaid plus the 40 or 56 that they get, the paid sick leave that they get each calendar year. So it has to be a pretty generous PTO policy. And I would suggest any company consult their employment counsel to ensure that their existing PTO policies comply with.
What? I mean, what would be the benefit of that, Andrew? I mean, it sounds like the only benefit would really be that they don't have to track accruals. That would be, I mean, is there any, instead of having to track, 1 hour for every 30 hours worked, and you just give them all their time immediately.
Correct.
The downside, of course, is if you have a workforce with a lot of turnover, employees could take a whole bunch of unpaid and paid leave immediately, and then they could quit. They could resign, and then you've paid them all this
Yep.
time that they might not have. So I think there's a tension there. There's a pro and a con to doing it that way. I also thought I would point out, it's a little tricky. According to the city, the prenatal leave, the 20 hours of prenatal leave, that has to be a separate policy. That is in addition to, because of course it's in addition to, because everything's in addition to, it seems. The 20 hours of prenatal leave needs to be its own separate policy. Don't combine it with sick leave. Don't combine it with paid or unpaid, safe or sick time. Separate 20-hour prenatal leave policy, please.
All right. So other than the 32 hours of unpaid safe and sick time that's now provided to employees, the next key change to the city sick leave law that we're seeing with these new amendments is now the expanded reasons for which safe or sick time can be used, and that's paid or unpaid. Again, the law doesn't distinguish between paid or unpaid time when discussing the reasons for which it can be used. Okay, and the law has certainly evolved over the years to allow employees to use sick leave for various other reasons other than the employee just being sick. So just as a reminder, prior to these new amendments, the pre-existing reasons for which safe and sick time can be used under the city law include when the employee is sick or seeking medical care, for example, if they have a doctor's appointment, if the employee is caring for a family member, which is very broadly defined. If the employee is caring for a family member who is sick or seeking medical care, the employee can utilize their sick leave. It can be used during public health emergencies, which became part of the law during COVID. And it can also be used for various safe time purposes, as the law calls it. That is, if the employee or the employee's family member is the victim of domestic violence, a family offense matter, a sexual offense, stalking, or human trafficking, the employee can use safe time for various permitted purposes, such as to seek counsel from a private attorney, to participate in legal proceedings, to relocate, to do certain things that will help bring safety to the employee or their family member. They can use it for that purpose as well. So again, those are the purposes, the pre-existing purposes for which employees are already able to utilize safe and sick time. Now, effective February 22nd of this year, employees can also use safe and sick time for these 4 new reasons listed on the screen. Okay, the first is to care for the employee's minor child or care recipient. A care recipient is defined as an individual with a disability who is the employee's family member or who lives in the same household as the employee and depends on the employee for care and to meet the needs of daily living. So that's one of the new reasons sick leave can now be used. The second, to initiate, attend, or prep for legal proceedings related to subsistence benefits or housing to which the employee, the employee's family member, or their care recipient is a party. Third, the employee's place of business closes or the employee must care for a child whose school or child care provider closed or restricted in-person operations by order of a public official due to a public disaster, or if there is a directive from a public official to remain indoors or avoid travel during a public disaster that prevents the employee from reporting to work. I know that sounds like a lot. A public disaster is essentially defined as some kind of catastrophic event, which could include severe weather conditions, that is a declared public health emergency by either the mayor, the governor, or the president of the United States. So just taking this example, the first day that the law took effect, we saw this third bullet point get implicated. The amendments took effect on February 22nd of this year, which was a Sunday. And that Monday, we had a big snowstorm here in the city, which Mayor Mamdani declared a state of emergency. And many employers closed their businesses that day, or employees were unable to report to work that day. And because of that, that is now a permitted reason for which employees can use sick leave, which is certainly interesting if you think about it, particularly, again, for the employers that had to close their business. Because the purpose of this law has always been to provide employees the ability to take scheduled time off from work if they were sick or if they had a doctor's appointment, whatever it might be. But the idea was there was a workplace or there was an office for them to report to that they could not report to because they were sick. And with this purpose, this is allowing employees to utilize their sick leave in the event the employer's business had to close. So it just, again, it shows how much the this law and the availability of this time off has evolved over the years. So if you had to close your business during one of these snowstorms that were a declared state of emergency, employees could utilize their paid sick leave for that day of absence. And finally, employees can now also utilize sick leave for certain circumstances when they or their family member is the victim of workplace violence. So this adds to the safe time purposes for which employees can utilize sick leave. I mentioned earlier, employees can utilize it when they or their family member is the victim of domestic violence, stalking, a sexual offense or family offense matter. And now also it includes if they're the victim of workplace violence and they need to take time off to speak with an attorney, obtain counseling, or take other actions to help their own safety or the safety of their family member.
Yeah, I just want to reiterate something Andrew already said, but I think it's critically important. And it wouldn't surprise me if there was a mix-up on this, but just to be perfectly clear, the 4 bullet points on the screen are the new reasons, that is the expanded reasons that employees can use safe or sick time. These are not all of the reasons. These are just the new ones. So I don't want anyone to print out this slide and think that this is the entirety of what the safe and sick time law provides. These are just the new or expanded reasons.
Yeah, good point, Jason. Thank you for clarifying that. Okay. We talked about paid prenatal leave a little bit in the beginning. And again, the amendments to the city's law now codified already existing New York state law. So this paid prenatal leave law, again, it's a New York state law, which obviously captures New York City employees as well. It took effect on January 1 of 2025, and it requires all employers in the state to provide their employees working in New York with up to 20 hours of paid time off to obtain certain healthcare services during or related to their pregnancy. So if you have a pregnant worker who has to go to a doctor's appointment to monitor her pregnancy, they have this 20 hours of paid time off available to them. And again, as we've said before, this is in addition to their already existing paid and unpaid safe and sick time. So if an employee is pregnant and they need to obtain healthcare services during or related to their pregnancy, you need to first allow them to utilize this 20 hours of paid time off before they start tapping into their paid sick leave or their unpaid sick leave. Just a few notes on the paid prenatal leave. This is only available to the pregnant employee. It cannot, for example, be taken by a spouse or partner of the pregnant employee who is accompanying the pregnant employee to a doctor's appointment. It's only available to the pregnant employee. A family member, spouse, partner who's with the pregnant employee, they can utilize their paid or unpaid sick leave, but they cannot utilize this 20 hours of paid prenatal leave. Another point, just to mention again, this paid prenatal leave, like the new 32 hours of unpaid sick leave, is available to employees immediately. It's immediately available for use. So if you hire someone who is pregnant, they have the ability to utilize this 20 hours, this time off immediately upon day one of their job. So again, just something to be mindful of. And again, it's something that they can use before they have to tap into their regular accrued paid sick time or their unused or unpaid safe and sick time. And administratively, as we've mentioned, there are now 3 buckets of time off that employers need to track. You need to track paid safe and sick time, unpaid safe and sick time, and paid prenatal leave. That's specifically required by the law. Employers have to track when employees request and when they use this time off. And we have to include it on employee pay stubs. which brings me to the next slide here. Um, the city's law specifically requires, and I think this became effective in the 2020 amendments, but the city's law specifically requires that we track this time on employee pay stubs that are given to employees each pay period, or at least in some other written or electronic format, again, that is given to employees each pay period. So for paid safe and sick time, this needs to track the amount that they accrued during the pay period, the amount, if any, that they used during the pay period, and the remaining amount available for use in the calendar year. Again, this would be no more than 40 or 56 hours, provided that you included a usage cap in your sick leave policy. Okay, so again, for paid safe and sick time, you need to track on employee pay stubs each pay period, the amount that they've accrued, the amount that they've used, and the total amount available for use in the calendar year.
Yeah, and this is, there's a question about what employers get wrong. We see this wrong all the time. We'll see a policy that says you cannot roll over any accrued but unused sick time from one calendar year to the next. That's incorrect. The law mandates that for paid safe and sick time, that is the 40 hours or the 56 hours, the law mandates that you roll those hours over from one calendar year to the next. But the opposite is also true, which is that you are allowed, as an employer, you are allowed to cap usage in that subsequent calendar year as long as it's in your policy, which again underscores or reflects the incredible importance of focusing on the exact language of your policy. Because if you don't focus on the exact language of your policy, I'll tell you who will focus on the exact language of your policy. First of all, your employees will. The, my experience as an employment lawyer for about 20 years is that there's not many portions of your employee handbook that employees are really going to study very hard. Most of the handbook is going to go largely unread for the most part by employees. Not your sick leave policy. That's going to be carefully reviewed by employees, and now it's going to be clip and pasted into ChatGPT or Grok or something to see what's available to them. So, in addition to the regulators looking closely at the language of your policies, your employees are going to carefully study it. So, if you want there to be some cap on usage, it better be in your policy. Otherwise, the result could be perverse, which is you could have 56 hours one year, roll over the 56 hours, and they could have another 56 hours, and that they could use 2 times 56 hours in a single calendar year. Is that what we want? Is that what the intent is? I don't think so, but what does our policy say?
Yeah, great point, Jason. Okay, so we talked about what needs to be tracked in terms of paid safe and sick time. We also now need to track unpaid safe and sick time. You have to include on the pay stub or in some other written format each pay period the amount that the employee used during the pay period and the amount that remains available for use in the calendar year. And then finally, paid prenatal leave. This also needs to be tracked, but there's a caveat here. We're only required to track paid prenatal leave on the pay stub or in some other written format, again, each pay period, if the employee uses paid prenatal leave in that pay period. So if an employee does not use any paid prenatal leave in a work week, you do not have to track their paid prenatal leave usage on the pay stub. It's only for pay periods in which they actually utilize the leave. So if an employee takes a day in 1 week as paid prenatal leave, 8 hours, you need to track on the pay stub that week that they used 8 hours of paid prenatal leave and they have 12 hours of paid prenatal leave remaining, and that's available for use.
Right. So the upshot here, and this is important, the upshot is for every employee in your organization, we do not want to just put on everyone's pay stub. You have 20 hours of paid prenatal leave available. We do not want that. We do not want to put that on every single employee's pay stub. That would probably be, there'd probably be a bad result associated with that.
And again, a lot of this sounds technical, and it is, and it's administratively challenging. But as we've mentioned throughout this program, the city is very active in their investigations on these issues. If there is a complaint from an employee and the city's doing an investigation, I can tell you because I'm in the middle of, I think, 3 of them right now. They're going to ask you for a copy of your safe and sick leave policy. They're going to ask to see samples of pay stubs or where employees are notified of the amount of time that's used each pay period. And they're going to ask to see the notice of rights document that you're required to give to employees upon hire. So please make sure that you're complying with these requirements. It is very important. Okay, finally, just a note on the New York City Temporary Schedule Change Act. This law previously required employers to allow employees to essentially change their work schedule up to 2 times per year on one business day each time. Whether it was to take an unpaid leave, whether it was to change their work hours or swap a shift with another employee, employers were previously required to allow employees to do this up to 2 times per year for certain defined personal events. Since the amendments to the sick leave law that we're discussing today, now that employers are required to provide this 32 hours of unpaid safe and sick time, the city essentially did away with this law. The law simply says now that employees have a right to request a temporary change to their work schedule, and employers must respond to that request by either approving the request, denying the request, or proposing some alternative. Okay, so it doesn't place any meaningful obligation on an employer. If an employee requests a change in their schedule, a temporary schedule change, you can simply deny the request. The caveat there is just we cannot retaliate against employees for making a request to temporarily change their schedule. But we did want to note this because it is part of the amendments that went into effect on February 22nd. And it is actually a bit of good news because we no longer have a meaningful obligation, I should say, under this law.
Yeah, I just want to point out that once again, you have to pay special attention to your written policies because here's what's going to happen. Yeah, this is going to happen. Employers are going to see this and are going to think, oh, that's good news. I guess I don't have to grant 2 changes per year anymore with respect to some temporary change in work schedule. And then the employers are going to be diligent about changing their earned safe and sick time policy. But here's what's going to happen. Employers are going to forget that somewhere else in their handbook, they have this. They have New York City temporary change of work schedule, and they're going to leave that in there. And it's going to continue to say, it's still going to say, you have the right to 2 changes in your work schedule per year. It's going to still say that. And so the point is, if we want to be compliant with and take actions to effectuate these amendments, we would also tend to that in our handbook, and we would change this section. We would change it so that instead of it being a right to actually get 2 changes in the temporary work schedule, it would simply be the right to request it. So don't forget about this section. Otherwise, employees may request it and say, well, the handbook says I'm entitled to it. You don't have any right to deny it. I'm entitled to it. Don't forget about making a change to this section.
You know, Jason, that's a perfect segue to our final slide on these action items and takeaways.
Yeah. Well, Andrew, we try to weave into the presentation the action items and takeaways even before we get to the final slide in our conversational style of presenting. That said, for anyone watching, there are, as you can tell, there are things to do. You have to update your policy with respect to protected time off. That is both the unpaid and paid to the extent applicable. unpaid and paid safe and sick time amendments for the paid prenatal leave, which is separate, a separate policy, and any changes with respect to the prior slide, which was the temporary change in work schedule. You have to change your tracking. You have to update pay stubs, as Andrew was describing. Uh, and in addition, there is a very new, very lovely poster that we have to distribute to employees. A link is attached or is in this slide. So employers can click on the slide or click on the link in the slide and look at that, and that needs to be disseminated to employees and posted. And then really, training. I can't emphasize training enough. We as employment lawyers find that if we're going to make it another analogy to there being a weak link in a chain, it's often managers because they're so busy doing just that. They're managing up, they're managing down, they're managing clients. They're incredibly busy. They're working with their superiors and their subordinates and but those are the people who are most likely to somehow be involved with either granting or evaluating time off and what it means for the team and any sort of disruption in workflows. So anyone who is going to have any authority to decide these sort of issues. So suppose someone is the person to whom sick and safe leave requests are to be made. That person better be trained on this law. Now, when I say trained on the law, I'm not suggesting that they need to take 4 weeks off to go to college to learn this law, but they better know the highlights and they better have read our policy and understand our policy. And in generalities, they better understand how it works and to issue spot. Because the way that we see a lot of issues is that like the C-suite team doesn't even know that there's an issue, but it is some mid-level manager who has said, no, you're not allowed to take off time for that, to take care of that child or to help your mother with some. You're not allowed to. We have a deadline. We have a project. You're not allowed to take that time. No one even knows about the issue other than that single manager. So again, it is at the managerial, especially the mid-level managerial level, that we often see the most amount of issues. Those folks, as part of the managerial responsibilities, they have to be trained. They have to understand how to handle sick time requests or safe time requests. And again, they don't have to study this for many hours, but they should at least have a working framework with respect to whatever our policy is.
Yeah, one point I just want to add here, Jason, with respect to the policy and the notice of employee rights, it's very important that we maintain some kind of record that demonstrates that these documents were distributed to and received by the employee. Okay. It's not specifically required that employees sign the policy or that they sign the notice of employee rights. But I think the FAQ guidance that the city puts out specifically suggests that employers get the employees' signatures to these documents, because we have an obligation to maintain records showing that we distributed these documents to employees and that they received it. And the best way to do that, of course, is to get some sort of signature acknowledge or other, electronic acknowledgement from the employee to be able to demonstrate that. And once again, in our experience in dealing with investigations regarding compliance with this law, that is something the city will ask for. They will not only ask to see the policy that was in effect at the time the employee made the complaint or was working, they're going to ask to specifically see how you provided the policy and the notice of rights to employees and to demonstrate that they received it. So just another point just to be mindful of. And you need to maintain these records for at least 3 years. It's a 3-year record keeping requirement That comes specifically from the law.
All right, Andrew, one question we have is, can a business deny a schedule change if it just doesn't work for the business? And is the employer required to offer an alternative similar to, for example, the Americans with Disabilities Act or New York State or New York City human rights law, where you have to engage in an interactive dialogue? And if the employee's request for a disability accommodation doesn't work, then the employer next step could be proposing a reasonable alternative. Is that, in your view, is it the same with respect to these amendments to the temporary change in work schedule? I know my opinion, but let's see yours first.
Okay, so does this qualify as a disability? You threw a lot at me right there. Um,
Yeah, no,
if look, if
let's say it's not disability related. It's just it's I don't know, a kid's soccer game or whatever, or I'm a baseball coach, so we'll say it's a kid's baseball game. I mean, the question is just, can I deny a temporary change in work schedule if it doesn't work for my business, and do I have to offer an alternative?
Yeah. So the answer to that question is yes. Now, with the changes to the Temporary Schedule Change Act, you have no affirmative obligation to grant an employee's request to change their schedule. Okay. You either approve it, deny it, or propose an alternative. There's no obligation for you to approve it. There's no obligation on you to propose an alternative. If it's for a sick leave reason, if they're requesting that change for a sick leave purpose, then and you deny the request for the schedule change, they can simply utilize their available safer sick time, whether it's paid or unpaid. They can utilize it for that purpose, assuming it's for a permitted purpose under the sick leave law.
Yeah, I agree. The answers plural are yes and no. The yes, you can deny it for if it just doesn't work for your business, and no, you are not required to offer an alternative necessarily. Um, Look, I mean, the old saying, bad facts make bad laws. So if there's a reasonable request, try to handle it diplomatically. I was going to come up with the absurd analogy that you could deny it just because you don't like someone's t-shirt one day, which I guess is true as a matter of law, but may not be a best practice or conducive to employee retention, morale, and cultural issues.
Yeah.
Um,
And just going to the other point you raised, Jason, and I know we could do an entire separate program on this, but if it was something that qualified as a disability under whether it be the ADA, the New York City human rights law, the state human rights law, if they requested a temporary change in their schedule because of a disability and it's a one-time request, that might be a reasonable accommodation that we would need to provide. So just be mindful of that. There are differences to the extent that the employee suffers from some condition that qualifies as a disability under applicable law.
yeah,
And
true.
we can always talk about that at another time.
So it looks like we're out of time for today, Nadia. Um, if any of the attendees, whether live or most likely viewing the recording, because my understanding, Nadia, is that this is going to be made available on the website to members of the Manhattan Chamber. So if any viewer of the program wants to get in contact with us and has questions about this program, we certainly would be delighted to hear from you and to answer any questions that you have.
Thank you so much. This was phenomenal.